Hey everyone, welcome back to the channel. Today's video is definitely one you won't want to miss. If you remember the sovereign citizen case we talked about a few months ago, get ready, because a brand new clip has appeared and it completely changes the situation. What you're about to see is even more shocking, more revealing, and honestly harder to believe than what we covered last time. Stick around, because once you watch how everything plays out, you'll understand why this case has suddenly taken a dramatic new direction.
For the record, I am the beneficiary of the Frank Anthony Michaud Jr. estate. I am the authorized representative, and I appoint you, the judge, as the trustee.
Near the end of that previous video, Judge Martin briefly mentioned that the defendant's next court appearance would take place in front of Judge Oakley. Now, if that name rings a bell, it's because we've already talked about Judge Oakley on this channel before. And one thing about him is crystal clear. He has absolutely no patience for sovereign citizen arguments. There are no games, no drawn-out debates, and no tolerance for imaginary legal theories. So the moment this new clip surfaced, I had a pretty good idea of where things were headed. That's exactly why I knew this hearing would be worth watching all the way from beginning to end.
Barcode, though, this is what you signed up to do. You're a public servant.
Unless you are a price on a can of beans, we don't need a barcode. All right, appearances for the people versus Frank Michaud Jr.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have work, so yeah, you're on trial.
Are you ready to sit at the desk representing yourself?
The judge needs to address you, sir. Alright. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
Maybe I'm not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to...
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary.
Honestly, I wish more judges handle their courtrooms the way Judge Oakley does. He cuts straight to the distractions, focuses on the facts, and refuses to waste time entertaining theatrics or invented legal arguments. If there were ever a perfect definition of no nonsense, he would probably be it. And just as a heads up, as this hearing continues, things don't settle down. In fact, they escalate quickly. The tension rises minute by minute. The situation grows more chaotic, and everything builds toward an ending you probably won't see coming.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections. They are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the Constitution?
Hold on, what? Are you picking him up? That's one of the reasons I want you up here is through the microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to the
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay. Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
I reserve all rights.
Now, are you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the...
This moment alone makes it pretty clear that the defendant doesn't truly understand what he's doing. Deciding to represent yourself in a criminal case, especially when a qualified attorney is standing right there ready to help, simply doesn't make sense. On one side, you have a trained professional who has spent years studying and practicing law. On the other side, you have a defendant who clearly hasn't. That decision isn't confidence or bravery. It's a serious misunderstanding of just how critical and complicated the situation actually is.
Okay.
So, with that being said...
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So, today...
You have a jurisdictional argument you want to make?
Well, I served notice...
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a...
Yes or no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that...
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have...
The truth is, you really have no business representing yourself if you can't even explain the basic differences between common law, maritime law, and statutory law. Those are foundational legal concepts. Without understanding them, you're not building a defense. You're practically guaranteeing your own failure. Lacking that kind of knowledge doesn't just make the process more difficult. It immediately places you at a major disadvantage the moment you begin speaking in a courtroom setting.
My jurisdiction...
It's only two...
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is...
This is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right, where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so...
You said you wanted a sworn complaint.
From an injured party. Who have I injured, for the record?
The state of Michigan.
How can I injure
are bringing
the
the charges.
How can I injure the
Sir,
state?
sit down. Sit down.
I'm not...
Sit down, or I will hold you in contempt.
Another threat, wow.
You're probably going to hear more than one.
Do you really see the situation that way? Because from what I'm watching, this doesn't look like injustice at all. Instead, it looks like a judge who has completely lost patience with someone who refuses to listen to basic instructions. There's nothing complicated or controversial about what's happening here. It's simply stubbornness. And that stubbornness is about to land him in jail for one very simple reason. He refuses to sit down, refuses to follow the most basic directions, and refuses to accept that courtrooms operate under rules that he cannot ignore.
I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
Right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Can we take a moment to appreciate judges like Judge Oakley? He's the kind of judge who doesn't spend endless time lecturing or avoiding the issue. Instead, he allows people to experience the consequences of their own choices quickly and clearly. There's no confusion, no mixed messages, just firm authority and straightforward communication. Honestly, courtrooms everywhere would function much better if more judges managed situations with the same level of control, confidence, and accountability.
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people call Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of a probable cause conference, and I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause. This is a preliminary exam.
This
is okay. So right here,
this is the probable cause hearing.
It says.
All right, stop. Right now, the question on the table is you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what grounds am I denied? Not
because you didn't give me a valid objection.
I object.
You can't just object. You got to explain with the valid objection to the evidence.
That we are having a preliminary exam when I haven't had a probable cause hearing, and I did not.
They're the same thing, Mr. Michaud.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that?
At what point?
At this point, we're dealing with someone who simply refuses to listen. If he paid even a little attention to what the judge is carefully explaining, he would realize that a probable cause conference is only a discussion about the case. It isn't the hearing itself. The actual probable cause hearing, the very thing he keeps insisting was skipped, is taking place today. Nothing was overlooked. Nothing was ignored. Moments like this make it painfully obvious that some individuals need the same basic explanation repeated again and again just to keep up with what's actually happening in the courtroom.
If this is a hearing, or
You didn't
right,
waive it.
so
There's nothing to hold.
Do I have a right to have a probable cause conference?
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, you've ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, you want to have an exam today?
Well, I wanted to address some. I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I want like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
Criminal
the
what?
bid bond.
Hold on.
I
What?
requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think
okay.
listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe. Okay? That's just the way it works. My courtroom, I get to decide how.
This right here is exactly how a courtroom should be run. The judge is firm, crystal clear, and completely in control from the very first moment to the last. There's no confusion about who's in charge, no room for games, and no tolerance for disruption. Just order, authority, and a process that moves forward the way it's supposed to.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you
Can
got
you-
in front of you.
well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice, and
Great.
you haven't-
Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am
recognize
not
any
a
of that.
United States citizen. I am
Stop.
actually
Hold on.
identified.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean,
prove
hold on.
it?
It does, it should mean something
Can
because,
you prove it? Please prove
can
it.
I prove what?
Prove that I am not that I am the artificial person. Period.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can prove.
Okay, so
Hold on, you've asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I
You
actually
proved it
you
for
threatened
me.
You threatened me.
But if you're not you, the threat means nothing.
It doesn't mean.
And if it truly meant nothing, then why are you still following the judge's orders? That's the detail that reveals everything. On some level, you clearly understand that you're wrong. And just as clearly, you recognize that the judge is right. That's why the arguments suddenly stop and compliance begins the moment the consequences become real and unavoidable.
But
Okay.
you still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen
you
to
have,
me. Mr.
you
Michaud,
have, you have
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So-
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
This is the exact moment when delusion collides directly with reality, and the stakes couldn't be higher. A person's freedom is literally on the line. On one side are imaginary legal arguments that might sound convincing in someone's head, but hold no weight in an actual courtroom. On the other side is reality, which has a very effective way of delivering consequences when the law is ignored. And in situations like this, reality always wins. The video might be approaching its conclusion, but the judge still had several important points he needed to address before everything came to an end.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
On the color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me, and I don't mind that, but I just can't let him try to run things.
Yeah. No.
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him.
It don't play here.
The court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's the worst part about all these cases, right?
Yeah.
Because sometimes they've got a chance if they just.
We had a good
Ron White,
argument.
right?
Yeah.
Got a constitutional right to remain silent. Just can't.
All right, everyone. That brings us to the end of today's video. But the story itself isn't finished yet because of the defendant's contemptuous behavior. The probable cause hearing never actually reached completion. That means there's a very strong chance we'll see another special appearance in front of Judge Oakley in the near future. There's also a possibility that the situation could move forward to a circuit court judge as well. So if you found this breakdown interesting, make sure to hit the like button, stay tuned to the channel, and we'll continue following this case closely every step of the way.